Ganta Ramarao Garu, Chairman, Bar Council of AP, to preside over the function. ఈరోజు ఈ వన్ డే సెమినార్కి ముఖ్య అతిథులుగా ఇచ్చేసినటువంటి గౌరవ ఆంధ్రప్రదేశ్ అత్యున్నత న్యాయస్థానం తాత్కాలిక ప్రధాన న్యాయమూర్తి ఆకుల వెంకట శేషాయి గారికి, ఆంధ్రప్రదేశ్ అత్యున్నత న్యాయస్థానం న్యాయమూర్తి గారు చీకటి మానవేంద్రనాథ్ రాయ్ గారికి, చైర్మన్ బార్ కౌన్సిల్ ఆఫ్ ఏపీ గంటా రామారావు గారికి, ఆనరబుల్ జిల్లా జడ్జి మరియు సెషన్ జడ్జి కుమారి శ్రీ యామిని గారికి, నేటి మన స్థానిక న్యాయవాది బార్ కౌన్సిల్ ఆఫ్ ఏపీ మెంబర్ వేనాడు చంద్రశేఖర్ రెడ్డి గారికి, బార్ కౌన్సిల్ మెంబర్ మరియు బార్ కౌన్సిల్ ఆఫ్ ఇండియా మెంబర్ రామిరెడ్డి గారికి, నేటి సెమినార్కి హాజరైనటువంటి న్యాయవాదులకు, న్యాయమూర్తులకు మరియు ఎలక్ట్రానిక్ అండ్ ప్రింట్ మీడియా మరియు తదితర సిబ్బందికి అందరికీ నా యొక్క నమస్కారం. కార్యక్రమానికి నెల్లూరు నుంచే కాకుండా దూర ప్రాంతాల నుంచి కూడా ఈ కార్యక్రమానికి విచ్చేసినారు, మన్నించాలి. మరియు నాకు అందరికీ నేమ్స్ తెలియదు. బార్ కౌన్సిల్ మెంబర్స్ ఈ దినం ఇక్కడికి విచ్చేసినటువంటి బార్ కౌన్సిల్ మెంబర్స్ అందరికీ కూడా పేరు పేరున నా యొక్క నమస్కారం. అదేవిధంగా ఈరోజు ఈ కార్యక్రమంలో న్యాయమూర్తులు గారు చెప్పబోయేటటువంటి సబ్జెక్ట్ మీద మనం అందరం కూడా కాన్సన్ట్రేట్ చేసి మనకి వృత్తిరీత్యా చాలా ఉపయోగకరం కాబట్టి దాన్ని మనం వారి యొక్క లెక్చర్స్ని మనం వినాల్సి అవగాహన చేసుకోవాల్సిందిగా ప్రార్థన. మరియు నా యొక్క వినుభవం సెమినార్లో చెప్పడం బాగుండదేమో కానీ ఇంటరాక్షన్ విత్ బార్ కౌన్సిల్ మెంబర్స్కి ఈరోజు ఇక్కడ జరిగింది కాబట్టి మా నెల్లూరు బార్ అసోసియేషన్ మరియు న్యాయవాదుల తరఫున నా యొక్క రక్షణ విధంగా వారి వంతు గట్టిగా ప్రయత్నం గవర్నమెంట్ మీద ఒత్తిడి తెచ్చి ఆ యొక్క చట్టాన్ని రూపకల్పన చేయించవలసిందిగా మనవి. అదేవిధంగా న్యాయవాదులు మరణాంతరం వారి కుటుంబ సభ్యులకు వెల్ఫేర్ ఫండ్తో పాటు వచ్చేటటువంటి మ్యాచింగ్ గ్రాంటు గత కొన్ని నెలలుగా ఆగిపోయి ఉన్నాయి. దాని మీద ప్రత్యేక చర్యలు తీసుకొని ఆ మ్యాచింగ్ గ్రాంట్ని న్యాయవాద కుటుంబ సభ్యులకి అందే విధంగా వారు ప్రయత్నం చేయాలని విన్నవించుకుంటున్నాను. మరియు ఈ దినం ఈ సభకు అందరూ వచ్చినటువంటి న్యాయవాదులకు మరియు అందరికీ కూడా నా యొక్క ప్రత్యేక ధన్యవాదాలు తెలుపుకుంటూ సెలవు తీసుకున్నాను.
Chief guest of this today's function, Honorable Acting Chief Justice Sri Akula Venkata Sesha Garu, Sri Justice Chekata Manavendra Rai Garu, District Judge Yamini Garu, my friend Bar Council of India member Reddy Garu, Yanati Chandrasekhar, my colleague in the Bar Council, my other colleagues in the Bar Council, the President of the Nellore Bar Association and members of the Nellore Bar Association, Honorable Judicial Officers, the advocate friends, senior advocates, my young friends, hospitality of the Nellore hosts. My dear friends, conducting of this seminar is part of continuous education. Though we have no sufficient infrastructure, we have started our operations and activities in a small premises with the courtesy of government at that time. All those limitations did not come in the way of Bar Council to discharge its obligation on various aspects, including conducting of these programs as a part of the continuous education program. After formation, immediately, we have conducted a seminar at Guntur, thereafter at Kadapa. At Kadapa also, that was the first time that Bar Council and Bar Association, Corona, the effect of virus, we could not continue our activity. As soon as this virus come down, we have again restarted. The Bar Council conducted a program at Visakhapatnam, thereafter at Eluru and Narsapur, and recently 3 days orientation program was conducted with the cooperation. On every occasion, every time, whenever we conduct such program, the Honorable Justice Sesha garu and Honorable Justice Manavendranath Rai garu readily accept our invitation and they are available, play a part in this sacred functioning of the Bar Council by taking a lot of pains, and we are always thankful to them and look forward to them. Now, under the auspice of Honorable Acting Chief Justice, we will be increasing our activity, and we are also will be taking steps to create a permanent infrastructure by establishing a lawyers academy. It is a dream. Since long time, all of us have been dreaming, and also not only dreaming, doing our best. Notwithstanding all the shortcomings, within a short period we are expecting, hopeful that we will be able to establish a lawyers academy at appropriate place with the active cooperation of the administration of the Honorable High Court under the auspices of the acting Chief Justice, and also with the, hopefully with the cooperation of the government. We are approaching the government for allotment of the site, suitable land, so that we are going to make it clear that except the land, we will not ask anybody any help. I am confident that around 40,000 advocates community will come forward to build our own infrastructure. With the confidence on all of you, I am proposing that please allot a site and we will construct a state-of-art building to have a permanent infrastructure, to undertake a training program for all the advocates, notwithstanding they are standing at the bar, age on the stage. It is need of the hour, because if anybody think that you learn everything, nothing is left, that is a misnomer. Then he will be irrelevant in the present day society. It is a dynamic field where changes taken place every day, because the maybe amendment of the, not only amendment of the acts, as a law of the land, and after enrollment, each one of the advocates, they try to come up on their own, learning on their own, by joining somebody's office or taking pains on their own effort. There is no systematic attempt or systematic training, or there is no institution till today. Therefore, it is the necessity of the time that all of us come together, establish an institution like Lawyers Academy. It is not somebody's responsibility, it is the responsibility of all of us, notwithstanding the cooperation, whether the state government is able to allot or not able to allot. I am expecting that all of us come together. Definitely we will be able to, if necessary, even by purchasing the land, because each one of us is responsible to preserve the prestige of this profession, and therefore all of us together, we can change the face of this profession for the benefit of all of us, or the benefit of the young generation, and the benefit of the future of this profession. Therefore, I request all of you to come together. We need not dividend. We are capable of doing that. Only thing is little change in our mind, and we should switch on cooperative mode instead of non-cooperative attitude. Therefore, my dear friends, please join your hands, and we should realize the importance, because certain practices, certain aspects, like a guru, we learn something by practice. We follow that practice which is followed by our senior, and same guru, whether right or wrong, same sentences we follow, same phrases we use, same adapt the same drafting. Therefore, instead of that, we shall try to improve our professional skills so that we can ahead of not only other professions, but also same profession in other parts of the globe. We cannot overrule, we cannot avoid competition, because now all of you are aware, recent policy that allowing the foreign lawyers to come and practice here, of course, not in the litigation, but in other activities. Similarly, those countries will be giving us reciprocation, permission, and all of you sitting at Nellore, you can also advise somebody on the Indian laws or practices here. Somebody who is located in United States or other part of the globe. Therefore, we shall be equipped ourselves, be ready to compete with the other professionals in other parts of the globe, so that we can also ahead with the other groups of people. My dear friends, I don't want to take much time because this day we have assembled and we have two learned judges who will throw light on those specified subject. Every minute, every second is a valuable, and we will pay our attention to the learned judges so that we will be benefited by their discourse. Their lifetime experience and their exposure to the not only the profession and also as a judges, they have enriched themselves and they wanted to share with us their wisdom, and it is the time for us to utilize this opportunity without missing every moment and pay full attention. I take this opportunity to thank Nellore Bar Association for being associated with us for conduct this wonderful program, and also I thank all these వెనాటిలకి వెన్నంటి ఈరోజు ఇంత మంచి ప్రోగ్రాం చేయడానికి మీరందరూ సహకరించిన వారందరికి కూడా నా హార్ట్ఫుల్గా మిమ్మల్ని అందరినీ కృతజ్ఞత తెలియజేసుకుంటూ I take leave from you. Now it is a time for us, Sri Akula Sesha garu, Honorable Acting Chief Justice of High Court of Andhra Pradesh, will deliver His Lordship's inaugural address.
సభకు నమస్కారం. President of this wonderful event and the Chairman of Bar Council of Andhra Pradesh, Sri Ghanta Ramarao garu, my learned brother, Sri Roy garu, other dignitaries on and off the dais, my heartful pranams to one and all. రామారావు గారు, మనం చాలా సంతోషపడాల్సిన, ఒక రకంగా గర్వపడాల్సిన విషయం ఏంటంటే 2019 సంవత్సరంలో మన ఆంధ్రప్రదేశ్లో మన హైకోర్టు ఏర్పాటు చేయడం జరిగింది. ఈ 4 ఏళ్లలో ఇంచుమించు నేను గమనించింది ఏంటంటే, చాలామంది యువ న్యాయవాదులు, యంగ్ అడ్వకేట్స్ అమరావతిలో మన హైకోర్టుకు రావడం జరిగింది ప్రాక్టీస్కు. ఈ సందర్భంగా ఒక మాట మీతో చెప్పాలండి. మేము గమనించింది ఏంటంటే, ఒక్క 10 సంవత్సరాల్లో మనకు తప్పనిసరిగా ఒక అద్భుతమైన బార్ ఏర్పడబోతుంది. అంత బాగా చేస్తున్నారు జూనియర్ అడ్వకేట్స్. యూ షుడ్ ఫీల్ ప్రౌడ్ ఆఫ్ ఇట్. వాళ్ళ బిహేవియర్ కానీ, వాళ్ళు ఆర్గ్యూ చేసే విధానం కానీ అద్భుతంగా ఉంటుంది. వాళ్ళు 100కి 70 మంది అట్లానే ఉంటున్నారండి. చాలా బాగా ఆర్గ్యూ చేస్తున్నారు వాళ్ళు. మనం ఏమి భయపడాల్సిన అవసరం లేదు. మన వ్యవస్థకు స్వర్ణయుగం ఉంది తప్పనిసరిగా. All of you know, only thing that enhances and multiplies on sharing is the knowledge. పంచుకుంటే పెరిగే సంపద జ్ఞానం మాత్రమే. మిగిలిన అన్నీ తరుగుతాయి ఇప్పుడు కూడా. Obviously, keeping the same in view, the AP Bar Council, under the leadership of Sri Ganta Ramarao garu, is holding this type of orientation programs frequently and periodically. For this great service, all of us should appreciate the Bar Council of the state of Andhra Pradesh. By what means? Unlike the other professions, all of you know, right from the beginning, the members of our profession are called learned members of the bar. In other, so that is the respect we are commanding in the society. Therefore, we should live up to that standard, up to those expectations. How is it possible? It is possible by way of organizing this type of programs, in my view. I request all the participants of this event to make use of this wonderful opportunity. Finally, I thank one and all for giving me this opportunity. Thank you very much.
The Honorable Sri Justice Manamendranath Rai Garu will give his message on this inaugural session.
My Lord, the Acting Chief Justice, Justice A.V. Sesha Garu, the Chief Guest of today's function, Chairman, Bar Council of State of Andhra Pradesh, Ganta Ramarao Garu, Member, Bar Council of India from the State of Andhra Pradesh, Reddy Garu, Member State Bar Council of Andhra Pradesh, Chandrasekhar Reddy Garu, and other members on the dais and off the dais of the Bar Council of State of Andhra Pradesh, learned advocates, judicial officers present here, the District Judge Yamini Garu. Good morning to you all. In this inaugural session of this seminar, I would first like to congratulate and appreciate the efforts being made by the chairman and members of the State Bar Council of Andhra Pradesh, Ganta Ramarao Garu and his team of members, for taking excellent initiative in introducing this new concept of organizing and holding seminars at the state level and in all districts to impart the young advocates and the law students with the legal knowledge that is required to enhance their skills and knowledge in criminal law and other civil laws and also the laws. Advocates who enters the portals of this justice, the temple of justice, the courts, namely the courts, and the law students who are soon going to enter the portals of the judges are only, hitherto they are only acquainted with the academic laws. They don't have any exposure towards the practical side of the laws in the courts. Therefore, they need some exposure and some training to gear up themselves to practice in the courts of law. Although some of the young talented advocates are doing well in the courts after coming to practice, still some advocates are finding it difficult as to acquaint themselves with the procedural laws and how to present the case before the court and others. These type of seminars help them to know the practical difficulties in the practice, while practicing in the courts of law. What is the march of law and how to equip themselves with that legal principles based on this march of law, and how to present the case before the court are all the necessary things which are to be learned by the youngsters. And these seminars will certainly help them to acquaint themselves with all these requirements that are essentially required to become an able and competent advocate in their future. Therefore, in my experience tells, both on the bench and as an active participant in these seminars, because they are your chairman and members of the Bar Council have been involving myself and Justice Sesha in almost all seminars in all districts. And fortunately, we are finding good response. Therefore, we are also very enthusiastically coming forward to participate in these seminars, because ultimately we are helping the institution here. Therefore, I once again appreciate the chairman and members of the Bar Council for taking good initiative in organizing these seminars. I hope and trust that all the participants in the seminar will hone their skills and will be benefited after hearing this seminar. Thank you.
Now I request Reddy Garu, Honorable Member of Bar Council of India, to deliver a brief and sweet speech.
చైర్మన్ గారు ఒక్క నిమిషమే ఇచ్చాడు. టుడేస్ ఫంక్షన్ ప్రెసిడెంట్ అండ్ చైర్మన్ ఆఫ్ ది బార్ కౌన్సిల్ హానరబుల్ గంటా రామారావు గారు, మై గుడ్ ఫ్రెండ్, అండ్ టుడేస్ చీఫ్ గెస్ట్ ఆఫ్ దిస్ ఫంక్షన్ హానరబుల్ జస్టిస్ ఏవి శేషాయ్ గారు, చీఫ్ జస్టిస్ ఆఫ్ ఆంధ్రప్రదేశ్, అదర్ సీనియర్ జడ్జ్ హానరబుల్ జస్టిస్ మానవేంద్రనాథ్ రాయ్ గారు, జడ్జ్ హైకోర్ట్ ఆఫ్ ఆంధ్రప్రదేశ్, and Principal District Judge Kumari Yamini Garu, my brother State Bar Council Member Chandrasekhar Reddy Garu, and my friend President of the Association Uma Maheswara Garu, my colleague Honorable Members of Andhra Pradesh Bar Councils, and invited judicial officers, senior and junior advocates, brothers and sisters. Good morning to everybody. Actually, regarding seminar, my brother Ramarao Garu and others are told about the seminars and workshop. Actually, we have two Ani Muchalu, Honorable Justice Sesha Garu and Manavendra Garu in Andhra Pradesh. Every time, the busy schedule, they want to serve the legal fraternity and particularly advocates. ఈరోజు ఎంతమంది జడ్జెస్ అంత టైం స్పెండ్ చేసుకొని ఒకరోజు ముందుగా సెమినార్ రావడం, వర్క్షాప్ రావడం అంటే నాట్ సో ఈజీ. ఒకరోజు ప్రిపేర్ కావాలి. వాళ్ళు కొంచెం ఒకరోజు వీక్లీ హాలిడే వస్తే ఆ హాలిడేస్లో 1 డే బిఫోర్ ప్రిపేర్ కావాలి. ప్రతి సెమినార్ రావాలి, ఏదో చెప్పాలి, ఏదో చేయాలి తప్పన వారిద్దరికీ. దాదాపు శేషాయ్ గారు అయితే 2013 నుంచి ప్రతి బార్ కౌన్సిల్ సెమినార్కి అటెండ్ అయినారు. ఇంకా మానవేంద్ర రాయ్ గారు అయితే ఆంధ్రప్రదేశ్ ఏర్పడినప్పటి నుండి కంటిన్యూగా ఎవ్రీ మీటింగ్ మనం పిలవడము, వాళ్ళు రావడము, నిజంగా మన ఆంధ్రప్రదేశ్ న్యాయవాదులు చేసుకున్నటువంటి అదృష్టము, స్టేట్ బార్ కౌన్సిల్ చేసుకున్నటువంటి అదృష్టంగా భావిస్తున్నాను. వారిద్దరు అంతటి పేషెన్స్తో దే ఆర్ కమింగ్ అండ్ గివ్ ఏ వాల్యుబుల్ డెలివరీ ఆఫ్ ది సిస్టమ్. అండ్ ఈ సెమినార్లు, వర్క్షాపులు అనేది కండక్ట్ చేయడం అంటే నాట్ సో ఈజీగా ఫైనాన్స్తో కూడుకున్న పని. అంతేకాకుండా అందరినీ గ్యాదర్ చేసుకోవాలి. ఆఫ్టర్ మహారాష్ట్ర, ఓన్లీ ద స్టేట్ ఆఫ్ ఆంధ్రప్రదేశ్ కండక్టింగ్ లైక్ సెమినార్స్. ఫస్ట్ ఇన్ ఇండియా, మహారాష్ట్ర కండక్టింగ్ వర్క్షాప్స్ every week and every month, the Bar Council of Maharashtra and Goa. After that, Andhra Pradesh is conducting like seminars and workshops in the entire India. We are the second place in India out of 20 states. ఇక ఇందాక మా మిత్రులు బార్ ప్రెసిడెంట్ గారు చెప్పారు అడ్వకేట్స్ ప్రొటెక్షన్ యాక్ట్ గురించి. బిఫోర్ ఎస్టర్డే ది బార్ కౌన్సిల్ ఆఫ్ ఇండియా ఇన్వైట్ ది యూనియన్ లా మినిస్టర్ టు ది బార్ కౌన్సిల్ ఆఫ్ ఇండియా. He assured clearly the protect bill presentation in this parliament session. ఎందుకంటే యాక్ట్ అంతా కూడా ప్రయోజనం. అందులో నేను కూడా ఒక కమిటీ మెంబర్ ప్రొటెక్షన్ యాక్ట్ బిల్లులో అవుట్ ఆఫ్ 5 members ద బిల్ వాజ్ ప్రిపేర్డ్ బై అస్ అండ్ ఆల్సో సబ్మిటెడ్ టు ది పార్లమెంట్. పార్లమెంట్లో కూడా ఈ సెషన్స్లోనే పెడతామని నేను అష్యూర్ చేయడం జరిగింది. అంతేకాకుండా ఇన్సూరెన్స్ కూడా కంట్రీ వైడ్గా ఆల్ అడ్వకేట్స్ అవుట్ ఆఫ్ 23 lakhs అడ్వకేట్స్ ఇన్ ఇండియా దే వాంట్ టు ప్రపోజ్ ఏ మెడిక్లెయిమ్ పాలసీ. ఫస్ట్ మనం చేస్తున్నాం ఆంధ్రప్రదేశ్లో, ఇండియాలో ఎవరు చేయలేదు మెడిక్లెయిమ్ పాలసీ, ఓన్లీ ఆంధ్రప్రదేశ్ చేస్తున్నది. ఇప్పుడు దీన్ని బేస్ చేసుకొని ఇండియా అంతా కూడా చేస్తారని చెప్పి యూనియన్ లా మినిస్టర్ గారు హామీ ఇవ్వడం జరిగింది. అది కూడా ఈ పార్లమెంట్ సెషన్లో బిల్లు పెట్టడానికి వాళ్ళు రెడీగా ఉన్నారు. అంతేకాకుండా 2 days బిఫోర్ పార్లమెంట్ స్టాండింగ్ కమిటీ ఒక డీటెయిల్ రిపోర్ట్ సబ్మిట్ చేయమని రిగార్డింగ్ స్టాండర్డ్ ఆఫ్ లీగల్ ఎడ్యుకేషన్, రిగార్డింగ్ ప్రొఫెషనల్ ప్రాబ్లమ్స్, రిగార్డింగ్ అడ్వకేట్స్ ప్రాబ్లమ్స్ అని అవన్నీ చెప్పడం జరిగింది. వాళ్ళన్నింటి మీద కూడా ఒక డీటెయిల్ రిపోర్ట్ తయారయ్యింది. 25th ది బార్ కౌన్సిల్ ఆఫ్ ఇండియా టీమ్ మెట్ టు ది ఆనరబుల్ పార్లమెంట్ స్టాండింగ్ కమిటీ ఇన్ దిస్ మంత్ అండ్ we are submitting all the entire country. We have no bar association, we have no washrooms, we have no women's bar association, we have no library, we have no sufficient library, we have no sufficient furniture. These are the deficits of the bar association. ఇప్పుడు మనం ఒక సెమినార్ కండక్ట్ చేయాలి, ఇట్లా బయట రావాలా. కోర్టు బార్ అసోసియేషన్లోనే కానీ ఒక హాల్ ఉంటే కనుక మనం ఇంకా బాగా చేసుకోవచ్చు, ఇంకా ఎక్కువ మంది రావడానికి అవకాశం ఉంటుంది. ఇందాక చెప్పారు రామారావు గారు నెల్లూరులో ఫస్ట్ టైం అని చెప్పి. కారణం అక్కడ ఉన్నటువంటి అవకాశాలు లేకపోవడము, చాలా బార్ అసోసియేషన్లో ముందుకు రాకపోవడము, ఇవన్నీ కూడా. బట్ ఫస్ట్ ఆఫ్ ఆల్ థ్యాంక్స్ టు ది చంద్రశేఖర్ రెడ్డి అండ్ నెల్లూరు బార్ అసోసియేషన్ ప్రెసిడెంట్ అదర్ మెంబర్స్ టు కండక్ట్ ద సెమినార్ ఆఫ్ ది ఫస్ట్ టైం ఆఫ్ ది నెల్లూరు డిస్టిక్. చంద్రశేఖర్ రెడ్డి గారు లేకుంటే ఇంత తొందరగా ఈ సెమినార్ ఇప్పుడు చేసిండే వాళ్ళం కాదేమో. థ్యాంక్ యూ టు ది నెల్లూరు బార్ అసోసియేషన్ అండ్ అదర్ థింగ్స్. అండ్ వన్ మోర్ థింగ్, the COP also extended to the entire India. Many members are awaiting COP. They could not receive any certificates and they could not submit the COP till today. These are the postponement. Even they are not submitting the COP, they can practice also. Up to high power committee will take a decision. The Supreme Court was appointed a high power committee consisting of 9 members. The committee will take the COP. Then after the completion of the COP, then only the other members are practicing. Now out of 25 lakhs of the advocates in India, 23 lakhs submitted in the COP. 30% of the advocates, fake advocates in India, that because of fake is only degree and intermediate, not for law degree and intermediate, they are not submitted properly. That also will be inquired our state bar council combination with bar council of India. So we have to conduct the joint meeting in the bar council of India and state bar council in every state. Due to pandemic situation 2020-21, we are not able to conduct the meetings, and I will request all the advocate community president and secretary, the September 23rd and 24th international lawyers meeting will be there. Nearly 15,000 of advocates will assemble on that day. 15,000. The Supreme Court Chief Justice of India will preside over the function, and the Prime Minister of India one day, and the President of India also will attend that function. I request all the advocates at the time, we have to inform to all the President of the Bar Association, all Bar Council members and President, Secretary and senior advocates will come to the Delhi Vijnana Bhavan on September 23rd and 24th. We'll take on that meeting, we'll take appropriate steps to the problems of the legal fraternity. And the Bar Council of India also planning to advocate training center at Goa. Actually, this month we have to foundation of the advocates training center at Goa, but due to some land problems, that program is postponed next month of September. After that, we had foundation that Advocates Academy at Goa and International Arbiter Center also. All the entire advocates will take practice training program free of the cost at Goa. And few words I have delivered in this meeting. I have given to the opportunity. Thank you very much, the President and Nellore Bar Association. Thank you very much. Thank you, sir.
Thank you, sir. Ram Reddy garu informed that our AP is the second in the country. All of us together, we will make it first within short period. I request Venadi Chandrasekhar Reddy garu to give his message on this inaugural session.
వేదిక మీద ఉన్నటువంటి పెద్దలు, ముఖ్యంగా నెల్లూరుని పెక్కుగా అభిమానించే ఇద్దరు సీనియర్ మోస్ట్ జడ్జెస్, ఒక ఆయన యాక్టింగ్ చీఫ్ జస్టిసు, తర్వాత మానవేంద్ర రాయ్ గారికి నెల్లూరు అంటే అది మొదట వచ్చినప్పటి నుంచి కూడా ఎప్పుడైనా అర్ధరాత్రి అయినా పిలవండి, నెల్లూరుకు మాత్రం తప్పకుండా వస్తానని చెప్పారు. ఈ మధ్య ఆయన చాలా వ్యయ ప్రయాసాలు కోర్చి ప్రతి దగ్గర ఒకరోజు ఈ మహానుభావుల పుణ్యం వైజాగ్లో 5 గంటలకు భోంచేయడం జరిగింది. ఆ తపన వాళ్ళిద్దరికి అలా ఉంటుంది. కానీ వినేవాళ్ళకి ఇప్పుడు పరిస్థితులు సక్రంగా లేకపోతే, జ్ఞానాన్ని నేర్చుకోకపోతే నష్టపోయేది మనమేం చెప్పక తప్పదు. వాళ్ళని ఈరోజు మన మీద ఉన్న ప్రేమతో జూనియర్స్కి అంతో ఇంతో ఒక్కడైనా మేము చెప్పే దాంతో బాగుపడితే మేలు అని మొన్న మన యాక్టింగ్ చీఫ్ జస్టిస్ గారు నాతో అన్నారు. అలాగనే మన రాయ్ గారికి కూడా అదే ఉద్దేశంతో ఉంటారు. ఎక్కువ సమయమైనా ఆయన చదివి రాత్రి 4:30 గంటకు వచ్చి మళ్ళా ఇప్పుడు మనకు ప్రిపేర్ చేసి చెప్పాలని ప్రయత్నంలో గట్టిగా అదే పని మీద ఉన్నారు. నేను పొద్దున కలిసినప్పుడు కూడా ముఖ్యంగా ఈరోజు యువత పెడదోవలను పడుతుంది. షార్ట్ కట్ మెథడ్స్ పైకి వెళ్ళిపోవాలని, అవి బిల్డింగ్లే సిమెంట్ లేని బిల్డింగులు అవుతాయి. మానవుడు ఎవరు శాశ్వతం కాదు. జీవితం అనేది తామరాకుపై నీటి పట్టులాగా ధర్మో రక్షితో, ధర్మాన్ని మనం రక్షిస్తే ధర్మం రక్షించబడుతుందని ఉద్దేశంతో జీవనం చేయాలి. ఏ వకీలైనా కూడా ఏదో సంపాదించి ఎవరికో ఇస్తే ఎక్కడికో రాదు. మనతో 1 రూపాయి వస్తే అందరూ కూడా మొత్తం ఎత్తుకొని పోతారు. ఆ పరిస్థితులు ఉన్నాయి. మా ఆకాంక్ష కూడా ఎంత వ్యయ ప్రయాసాలకైనా ఓర్చి జూనియర్స్ని సక్రమం దశలో పెట్టాలనే ఉద్దేశంతోనే ఇవి కండక్ట్ చేయడం జరుగుతూ ఉంది. తర్వాత రామారావు గారు కూడా చైర్మన్ అయినప్పటి నుంచి ఈ ప్రోగ్రామ్స్ అకాడమీ అన్నీ తీసుకురావాలని తపన పడేవాడు. మేము దాన్ని హాస్యాస్పదంగా కూడా భావించేది. కానీ పట్టుదలతో కడపలో మొదలుపెట్టి నన్ను అడిగితే రాయ్ గారు, జస్టిస్ రాయ్ గారు, శేషాయి గారు దాదాపు 15 సభలకి హాజరై ఉంటారని నా ఎస్టిమేషను. అంటే ప్యారలల్గా ఐఏఎల్ సభలుగా ఈ బార్ కౌన్సిల్ సభలు ఈ విధంగా సెమినార్స్కి వస్తున్నారు. మీకు తెలుసు, జీవితం అనేది ధర్మసూత్రాలపైనే మన న్యాయ వ్యవస్థ ఉంది. మనం పెక్కుగా చూస్తుంటాం. మద్రాస్ హైకోర్టులో చోళరాజు పుత్రుణ్ణి రథం కింద చంపేసి తర్వాత న్యాయం చేసిన పరిస్థితులు ఉన్నాయి ఈ దేశంలో. రాముడైనా ఇంకొకడైనా ఆ ధర్మసూత్రాల మీదనే జీవనం చేయాలి. అందుకని నేను ఎక్కువ సమయం తీసుకోదలుచుకోలేదు. మీరు మమ్మ చూసి రాలేదు. వాళ్ళిద్దరి సెమినారు సబ్జెక్ట్స్ని పరిస్థితుల్లో మీరు సక్రంగా ఓపికతో మీరు వారిని అనుసరించి మీరు జ్ఞానాన్ని సంపాదించాలని విజ్ఞప్తి చేస్తూ విరమిస్తున్నాను.
థ్యాంక్ యూ సార్. కొంచెం మనం డీవియేట్ అవుదాం, టీ బ్రేక్ తీసుకోకుండా, బికాజ్ ఒక 15 నిమిషాలు 20 నిమిషాలు వేస్ట్ అవుతుంది కాబట్టి అలా కాకుండా కంటిన్యూ చేద్దాం సెషన్స్ ఇలానే. ఒకసారి లంచ్ బ్రేక్ తీసుకుందాం మనం. నౌ ఐ రిక్వెస్ట్ శ్రీ ఆనరబుల్ శ్రీ జస్టిస్ ఆకుల వెంకట శేషాయి గారు, ద ఆనరబుల్ యాక్టింగ్ చీఫ్ జస్టిస్ హైకోర్ట్ ఆఫ్ ఆంధ్రప్రదేశ్, టు డెలివర్ ఈజ్ లెక్చర్ ఆన్ ది సబ్జెక్ట్ సివిల్ ప్రొసీజర్ కోడ్ విత్ స్పెషల్ రిఫరెన్స్ టు డిస్పోజల్ ఆఫ్ ఐఏఎస్. ఇది ఊరికే ఈ క్యాప్షన్ ఎలా ఉంటుంది కానీ మనకి సిపిసి అంతా కూడా వారు రివ్యూ చేసి, నా బోటి సిపిసి బాగా చదవని వాళ్ళకి కూడా సిపిసి అర్థమయ్యేట్టు, ఒక లేమ్యాన్ కూడా కొంచెం ఇంగ్లీష్ వస్తే ఆ సిపిసి సమగ్ర పరిజ్ఞానం వచ్చేట్టుగా చెప్తారు. నవ్ ఐ రిక్వెస్ట్ మై లార్డ్ టు కమ్ అండ్ అడ్రస్ us.
Before starting my version, I totally agree with Sri Venati Chandrasekhar Reddy garu. ఎందుకంటే వారు వేనాటి వారు ఈనాటి సమస్యలను చెప్పారు. వారు షార్ట్ కట్ మెథడ్స్ పనికిరావు అని. ఎస్, I totally agree with that. If we resort to shortcuts or short ways, you will have to face the cuts also in that. Short cuts means it includes cuts also. Therefore, we have to face the cuts also. Let us be aware of that. Sir, President sir, shall I begin my version, sir? Let us begin this session by offering salutations to two great and versatile personalities of the yesteryears. One is father of the nation, Mahatma Gandhi, and other Bharat Ratna Sri B.R. Ambedkar, father and author of the Constitution. In my opinion, this kind of programs are required to be conducted very frequently, as is being done by Bar Council of Andhra Pradesh, so that, as rightly said by our Chairman Bar Council, there can be interaction, not only interaction, but also introspection, which are highly essential for our profession and the system at large. Dear friends, very often we hear one thing, such and such thing shall be done in accordance with law. This is intended for young lawyers only. not for the experienced people. Yes, sir, you are youngster, please. Mic event, sir. Meaning of the law, kindly elaborate, sir.
Law is an instrument to regularize the behavior of an individual in the society.
Any other opinion from anybody on the definition of law?
Good morning, everybody.
Yes, Amma, please.
Law is the rule made by the lawmakers. It can be the legislature or the people from ages. And
Is it
being-
defined anywhere, Amma?
Look, we follow
At
law.
least is
isn't
it
it?
explained
Law.
anywhere?
It is definitely explained by the way we take it. Sometimes.
Good.
Thank you.
Any other participant, sir?
It's way of living, sir.
The way of living is law. Good. Yes, sir. Somebody is raising the hand. Yes, sir.
Sir, common thinking is law, sir.
Sir,
Is a common thinking is law.
common speaking.
Common thinking, sir.
Common thinking is law. So common sense is law according
Yes,
to you.
yes, sir.
Good, excellent. Yes. Anybody?
Sir, law is restricting the society. Law is restricting the society.
Restriction on the society is the law,
Society,
according
yes.
to you.
Yes, sir. Yes. Sir.
Good. Yes, anybody from the
Hello.
వామపక్షం వాళ్ళే పాల్గొంటున్నారు.
Law refers to a system of rules and regulations that are created and enforced by governments or other governing bodies to regulate the behavior of individuals and organizations within a society. I am Dr. Venkata Kapara.
Yes, sir. Excellent, sir. Excellent.
The rules and regulations are to be followed by the citizens, and these are
Amma,
made.
please tell your name and
I'm Suma, sir, and the rules and regulations are to be followed by the citizens, and these laws are made by the legislatures. And the
is there any
restriction-
provision under the constitution which deals with this?
Yes, sir. The laws are indirectly mentioned in the constitution, and these are mentioned indirectly to the people, for the people.
Sir, would you please tell
for the people, to the people, and by the people.
which provision of the constitution deals with this?
Right to equality and
Yes, sir,
the
somebody is saying, sir.
fundamental rights and DPSPs. The articles are defined in the constitution.
Article, as rightly said by one of our senior friend, Article 13 takes care of this particular aspect. That means an act made by the parliament or a state legislature, a rule or regulation, and clause 3 of Article 13 takes care of this aspect. Another doubt of mine is, can there be a law contrary to the constitution? రాజ్యాంగానికి విరుద్ధంగా ఏదైనా సరే చట్టం కానీ రూల్ కానీ రెగ్యులేషన్ కానీ ఉండొచ్చా? Yes, so many young friends are there. Please interact, sir. Supposing it is there, what should happen to that? Supposing it is made, what should happen to that? మాట్లాడండి అమ్మా, లేచి మాట్లాడండి, లేచి చెప్పండి. ఏమ్మా, మైక్ ఇక్కడ ఇవ్వండి.
We should challenge in the court, Your Honor. Writ jurisdiction. Article 226 and Article 32.
What is the provision of law under the Constitution? Yes, thank you. Thank you very much, Amma. Then another aspect is, all of you know that the laws can be categorized broadly into two kinds. One is substantive law. Another is procedural law. అసలు ఈ సబ్స్టాంటివ్ లా అంటే ఏంటి, ప్రొసీజరల్ లా అంటే ఏమిటి? వీ షుడ్ నో. ఎనీ ఐడియా ఫర్ ది యంగ్ ఫ్రెండ్స్? యంగ్ ఫ్రెండ్స్ ఓన్లీ. Yes, Amma. Once again, what is meant by substantive law? It deals with what?
Substantive law will give definitions of the crimes and punishments, but procedural law means how to implement the substantive law. Okay.
Yes. Yes, anybody from the right side? Right side, so there are so many youngsters on the right side also. Sir, please participate. Don't be hesitant. This is intended for all of us, for us also. Anybody from right side, sir? Substantive law deals with the rights and liabilities of the parties, whereas the procedural law prescribes the mechanism and the procedure for enforcement of such rights and liabilities. Then in this scintillating event and on this auspicious occasion, I have been asked to share my thoughts on Civil Procedure Code, of course with special reference to interlocutory applications. All of you know the Code of Civil Procedure 1908 regulates the procedure which needs to be followed by the civil courts. Sir, you can also sit, sir. You are an active participant. Sir, please come that side. You can sit there. Of course, CPC was codified during British regime. When this CPC came into force, when this Code of Civil Procedure came into being, yes, sir, somebody is raising their hand there. Third row from back. Second man, you only. This came into effect from 1/1/1909. CPC came into force with effect from 1/1/1909. And you also know that this Code of Civil Procedure has undergone a number of amendments. Last one being, would anybody say? Last amendment to Code of Civil Procedure in recent times. Number of amendments were made during that. (2002). Antarandi Krishna Reddy garu? That is 1/7/2002. You also know there are 158 sections and 51 orders in the Code of Civil Procedure. Some important sections are, it doesn't mean that other sections are not relevant and important. All are important because of the time constraint. Let us confine ourselves to certain provisions of law. Let us first see section 9 of the Code of Civil Procedure. Section 9, would anybody elaborate? Would anybody elaborate? Section 9 deals with what? Section 9 of Code of Civil Procedure.
Deal with suits of
Sir.
civil nature.
చెప్పండి సార్.
Suits of civil nature.
కొంచెం దగ్గర పెట్టుకోండి సార్.
Suits of civil nature. Any suit which is in civil character, that should be dealt by civil courts.
There is an exception to that, sir. What is that exception?
The exception is there any bar regarding the law? If the law declares that it is not dealt by the civil court, it is an exception. Because there is a law relating to AP Debts Relief Act in respect of small farmer. That law is declared, it is barred by the law. The civil court is no jurisdiction to deal with.
So according to you, all suits of civil nature can be tried by the civil courts. And there are two exceptions. One is barred by express provision of any special enactment, or implied bar. Implied bar is if an effective mechanism is created under a statute, then in that contingency also we cannot maintain this suit. That is the sum and substance of the provisions of section 9 of the Code of Civil Procedure. So for any relief of civil nature, we can go to the civil court. That's what section 9 says. Only under those two contingencies we cannot. There is a bar. Then, another important provision of law is section 10 of the Code of Civil Procedure. Section 10. Would anybody share there? Section 10. Yes, Amma. Somebody wants to say something. Yes, Amma, don't hesitate. Speak whatever you want to speak. చెప్పండి అమ్మా.
Res sub judice. Section 10 says.
What is the purport of section 10 అమ్మా?
Same suits and same cause of action. Same parties.
సేమ్ సబ్జెక్ట్ మ్యాటర్. నాకు డౌట్ ఉందమ్మా. సెక్షన్ 10 సేమ్ పార్టీస్, సేమ్ కాజ్ ఆఫ్ యాక్షన్, సేమ్ సబ్జెక్ట్ మ్యాటర్, సేమ్ పార్టీస్. These are the contingencies under section 10 of the Act. What does it say?
Matters are common.
Both the suits should be tried by two different courts. Can they be tried?
Yes.
Can they be tried
Yes.
simultaneously by two different officers? Cannot.
No.
Cannot be. Kadama?
Yes.
Previous. Then which suit has to be stayed? Is it previous suit or subsequent suit is the question now.
Subsequent suit, sir.
Amma?
Subsequent suit.
కొంచెం దగ్గర పెట్టుకోమ్మా.
Subsequent suit.
Subsequent suit, not the earlier suit.
Yes.
Supposing in a given case, suit for injunction simplicity is filed. Subsequently, a comprehensive suit for declaration of title and permanent injunction or recovery of position is instituted. Now, in that contingency, which suit has to be stayed? Is it the first suit or the second suit? Or there is an alternative mechanism for the same? Earlier suit, sir. In that contingency, section 10 can be invoked or not? Because specifically section 10 says subsequent suit. Ante kada sir? Then what is the alternative available to the party to avoid the multiplicity? conflict of opinions. If we allow those suits to be tried by two different learned presiding officers, sometimes we need to face two different judgments. Judgment may vary, we don't know. Then how to avoid is the question. Yes, this is one alternative. Section 24. Yes, sir. Then another important provision of law under the Code of Civil Procedure is Section 11 of the Code. Section 11, what does it say? Amma, please tell, please participate. Section 11. Emma? చెప్పండమ్మా. Section 11.
Res judicata, Your Honor.
Res judicata.
Between same parties, same cause of action.
What is barred under this provision of law?
When a suit is tried once, it should not be tried on another time, Your Honor. ఒకసారి ఒక కేసు డిసైడ్ చేస్తే మళ్ళీ సేమ్ కాజ్ ఆఫ్ యాక్షన్ మీద ఇంకో కేసు వేయడానికి లేదు.
So institutional suit on the same issue.
Yes, Your Honor.
అంతేనమ్మా?
Yes, Your Honor.
This is called res judicata. Then what are the objects of this provision of law? Is there any object behind this?
Delay, consuming of court time, delay of proceedings, public policy, opposite to public policy.
ఇంకా ఉన్నాయమ్మా?
Two alternate decisions వస్తే కన్ఫ్యూజ్ కదా, Your Honor.
Yes, sir. To put an end to the litigation.
Instead of going on filing the suits, it is to end the litigation.
Yes, sir. Any other object behind this? This particular provision safeguards the litigant public. Yes, sir, you are saying something, sir. Please tell.
Hello. The matter in issue must be the same in both suits. The parties involved in the subsequent suit must be the same as claiming under the same parties as in the previous suit. The matter in question must have been directly and subsequently in issue in former suit. The previous suit must have been heard and finally decided by a court competent to try the subsequent suit. In these conditions are met, the court in subsequent suit is bound by the decision of the court in the former suit, and the matter cannot be re-litigated irrespective of whether the previous suit was decided in favor of the plaintiff or defendant. This doctrine is essential to prevent multiplicity of litigation and to promote finality and consistency in the legal system.
That is the object behind that. To achieve the finality in the adjudication. You are correct, sir.
Thank you, sir. I am Dr. Venkata Kappara.
Good. Then, sections 15 to 20 tell about the place of institution of the suits. Then 33 deals with the judgment and decree. So what is meant by judgment? What is meant by judgment and what is meant by decree? Yes. Yes, would anybody?
Judgment means the statement
Sir,
of
Nellore
a
is
judge.
famous for civil advocates, sir, also.
It is defined in the CPC section 2.
Yes, sir, you are recollecting.
Judgment means the statement given by a judge in a judicial proceeding.
What are the various requirements?
The essentials of a judgment are the facts of the case, the issues, the law, basing on the evidence produced by the parties. The judge will decide the case basing on the evidence and arguments. all those should be reflected in a judgment. The
Then
judgment-
why should there be decree for the same, sir?
A decree is an operative portion of the judgment. The decree is an operative portion.
So that is the essence of the judgment according to you.
Yes. And it contains some other aspects of clerical matters, that is cause.
Thank you, sir. Thank you very much. Thank you so much. Sir, supposing you are aggrieved, a particular party is aggrieved by a decree of trial court. The remedy for the same is,
My lord, may I say something?
yes, sir, you are saying.
With your honors, to due respect, the judgment is nothing but to determine the rights of the parties finally and conclusively as contemplated under Section 2 of the CPC.
Yes, sir. Thank you. Thank you, sir, young man. Sir, supposing a suit is dismissed by the trial court, the remedy open for the aggrieved party is to file an appeal before the appellate court. I would like to know the provision of law which deals with that. First appeal. First appeal under which provision of law we normally file? And we should file.
Section 96 of CPC.
Is there any order, sir, regulating the same, sir? Amma? Ikkadi amma?
Order 40, Your Honor.
Order 40.
41.
One short of that. You have to add one more.
Yes, Your Honor.
41 kadamma. 40 deals with?
Receivers.
Receivers. 41.
Yes, Your Honor.
Then supposing you are aggrieved by the judgment of the first appellate court, what will you do?
Go for second appellate court or file revision or review.
Can we maintain a second appeal against any decree of the first appellate court? Is another question.
Final decree.
Supposing first appellate court renders a judgment, we file second appeal against that under section 100 of the CPC. On all judgments it is maintainable. What is the condition precedent to maintain a second appeal?
Facts of law. Question of law, sorry.
Is it merely a question of law?
Substantive question of law.
Substantial question of law. You are correct, sir. So unless there is substantial question of law, a second appeal cannot be entertained. Then what is meant by substantial question of law? Is another question. This means a question of law which substantially affects the adjudication of the issues, that is called substantial question of law. Not merely a question of law. It should have direct bearing on the adjudication. Amma, there is one amendment made to section 100 of the Code of Civil Procedure in 2002. Barring second appeals. Barring second appeals, there is one amendment made to section 100 of the Code of Civil Procedure. That is, section 100A was inserted. Does it bar all the second appeals? Or a few second appeals only? Is another issue. 100A bars the second appeal in money suits only. I am supposing an individual, a defendant in the money suit is aggrieved by a decree. Admittedly, it is less than 25,000. Is there any remedy for the same, for the aggrieved party? Can he file a revision against that order? Under Article 227, can he maintain a revision against that order? But our High Court said no. When appeal is barred with some laudable object, you can't maintain a revision also. It is final. Then since we are dealing with the interlocutory applications today, especially, let us concentrate on this. If we treat the suit as a tree, these interlocutory applications are branches to the tree. Before getting into the subject further, we should know the object behind these interlocutory applications. Young friends, anybody? Object behind filing of IAS. Is there any special reason for inserting these provisions of law enabling us to file interlocutory applications? Because we are filing suits, we need to avoid the decision in the civil suits. Then what is the object behind this IAS is another issue. The object of these IAS is, and the orders passed thereon, is the preservation of the rights of the parties pending final adjudication, and to see that the party ultimately succeeding in the litigation is not deprived of the fruits of the decree. This is ultimately the object behind these IAS, interlocutory applications. I would like to place before you certain important interlocutory applications which we come across in our day-to-day adjudicatory process. First application is, let us start from order 1. Suit for specific performance. And in that particular case, respondent, original respondent,
He can be permitted.
there is one provision under the specific, sir. Sir.
Will come to a just conclusion without any.
So according to you, sir, Commissioner,
The commissioner is very much necessary.
and 2000, you may also entertain a doubt.
Be there, balance of convenience must be.
Status card.
Last but not the least, the receive 3.
థ్యాంక్ యూ సార్. 3 సంవత్సరాలు లా చదివేటప్పుడు ఈ సిపిసి కనుక ఈ విధంగా చదివి ఉంటే ఎక్కడో ఉండేవాళ్ళమే. మీకు ఒక ఆప్షన్ మనం ఎక్సర్సైజ్ చేయాల్సి ఉంటుంది. లంచ్ బ్రేక్కు ముందే
Law is it is hit by Article 19 by taking.
Please, please. And has to be upheld, that is the law.
Please, my.
Because if you enhance the punishment, it would be disadvantage to the accused.
Please, my lord.
Okay.
Yes, yes, ma'am.
And that is, it amounts to imposing greater penalty than what was imposed as on date of commission of the act. That was actually what was prohibited.
Please, sir.
So the Supreme Court said that if it is advantageous to the accused and if it is reducing the punishment, it is the embargo under Article 20, Clause 1 is not applicable to such amendments is the question. Okay?
Yes, please,
And
my lord. Please, my lord.
The reason that is the reason. Now, so with this Article 20, Clause 1 which deals with ex post facto law is concerned, this is the law on the subject. Now the second article, clause 20, clause 2, which deals with double jeopardy, what we call as artifice convict or artifice acquit under our CRPC. Section 300 CRPC is the relevant provision dealing with this, artifice acquit and artifice convict. Now the Article 20, Clause 2 reads like this. No person shall be prosecuted and punished for the same offence more than once. If he is already convicted for the offence, he cannot be again prosecuted. It amounts to double jeopardy, which is hit by Article 20. Different offences constitute two different and separate offences. Then what is the position of law? That is the crux of the law relating to this article. For example, I can give you one example. You take section 499, which defines defamation. 500 is the punishment section under IPC. Suppose an election is going on, say that MLA, a legislature election is going on. One person disputes a pamphlet against the one candidate who is contesting, disputes a pamphlet, a purpose of pamphlet, making some defamatory allegation against the other. Now he files a case under 500 IPC for the offence of defamation, stating that by way of publishing this pamphlet, defamatory pamphlet, he has committed an offence of defamation against me under 500 IPC. So no doubt 499 which defines defamation attracts that. If any person by either by words, oral, written or verbal representation makes any imputations touching the person, then it is an electoral offence. For that purpose, it is also punishable. Now here, he has filed a petition, a complaint under 500 IPC to prosecute him for the offence of defamation relating to his individual Now he has taken a answer. Yes, Mr.
May I please, Your Honor?
Yes.
The first instance, the commitment of an act, on which date, at what time, in the presence of person, is necessary, and whether the first instance and the crime registered and the date of offence it must be quoted. And for another act, that is a second act, the date is, if the date is different and the date of offence, time of offence and the persons.
Mr. Date of offence, time of offence, everything same. Same set of facts, same acts. There he was prosecuted for 500 IPC. Now, when the trial is going on for the other offence, he has taken a defense, already was tried for the same set of facts under 500. My prosecution under 177 is not maintainable. It is hit by Article 5 acquit or convict under Article 20 Clause 2 or under 300 CRPC. Therefore, I am not liable, he says. What do you say? That's what I may say. Same set of facts, time of offense, date of offense, everything is...
Because of the same set of facts for against the one person or accused.
Constitute two distinct and separate offenses. One is under 500, one is under 177 of IPC. Therefore, there is no bar. What do you say then? I am asking I am giving a clear-cut example. The same set of facts constitute two different and separate. Then
It cannot be deviated into two set of facts because the facts and circumstances.
Mike.
My lord, it cannot hit by Article 20 Class.
IPC on the IPC. IPC. Yes.
Please, my lord. It cannot hit by Article 20 Class 2, my lord, because it is a distinct offence. It comes under the exceptions of Section 300 of CRPC, Your Honor.
Exception why it is a distinct offence?
What is the phraseology in Article 20 Clause? The same offence. Since it is a distinct offence, it cannot be treated as the same offence. That's why that protection cannot be extended.
Yes, good, correct.
Please.
I'll give the reasoning now. See, the same set of facts, same acts, here constituted two distinct and separate offences. Here an offence of 500 of IPC is purely personal against him. Okay, so that is one offence. There, the ingredient says, 175, 177, says, while dealing with electoral offence, if a person makes any allegation touching the character of a candidate contesting the election, here the person you use, there the candidate. Therefore, that is an electoral offence. This is an individual offence against a person. So, the court have held that it was interpreted that the same act or same set of facts constituted two distinct and separate offences. One is punishable under Section 499 or 500 of IPC. One is under 177 of IPC. Therefore, the principle of double jeopardy under Article 20 Clause 2 has no application to these facts of the case. Therefore, it can be prosecuted for both the offences. To the same effect, there are several decided case law. For example, I will give you another a decided case which is also an interesting case. Now take our insurance company. Insurance company is there. Now, was misappropriated by the employee of that insurance company. Now he was prosecuted under 409 of IPC. He was also prosecuted for the same set of facts under 105 Insurance Act, which says any employee of the company misappropriates any money paid towards premium, he is liable for under 105. And 409 also public servant misappropriating the public money, 409. Now he was prosecuted for both the offences. While trying for this offence, the court has convicted him under 409 of IPC, but acquitted him under 105 of Insurance Act on the technical ground that sanction required to be given under that act by the competent authority was not given. Now thereafter, the prosecution obtained the sanction required under 107 of the act to prosecute him for 105. Then he was again prosecuted after obtaining the sanction. Then he has taken a defense. I was already prosecuted under 409 for the same set of facts, and I was convicted, and I was acquitted under 105. Now again I am not liable for prosecution amount to double jeopardy. Then the matter went up to the apex court, held that no, the same act committed by him constitute two distinct and different offences, one under 409 of IPC, one under 105 of Insurance Act. Therefore, the mere fact that he was prosecuted under 409 cannot bar his prosecution under 105 of Insurance Act. This was decided in State of Bombay versus S.L. Apte, 1961. There, what the Supreme Court held is that in appeal, when under 132 of Supreme Court held, it was held that offences under Section 409 of IPC and Section 105 of Insurance Act, respectively, were two distinct offences. The trial and conviction under one would not be a bar to prosecute and punish under the other. In order to avail the benefit of Article 20, Clause 2, it is necessary that the second prosecution and punishment must be for the same offence as that of the first prosecution and punishment. Now understand? So, the test is that when a same act committed by a person constitutes two different, distinct and separate offences under two different enactments or under the same enactment, then the prosecution of the same act for one offence cannot be a bar for the another offence. That is the test. And this test you have to, while dealing with such cases, Section 26 of General Clauses Act also is relevant in the context to consider. Now, in another interesting case, in State of UP versus Prabhakar Kumar, 1966, there also a person was prosecuted initially under Section 25 Arms Act for being possession of a stolen revolver. A stolen revolver was found in his possession. He was prosecuted under 25 of the Arms Act. Now he was again tried for being in possession of same revolver for the offence under Section 411 of IPC. I was already tried under Section 25 Arms Act. I was evicted. Now saying that it was a stolen property, now double jeopardy under Article 20, Clause 2. Then the Apex Court held that the second trial under Section 411 of IPC was not barred by either of the provisions of the 20 Clause 1 or under 300 of CRP offences. There, possession of stolen revolver is only a made offence. Whether it is stolen article or not is not the necessary ingredient of a stolen one. Then he is liable for liable. Here, the prosecution theory is that he is in possession of a stolen article, whatever it may be a revolver or something else. When he is found to be in a possession of a stolen article, 411 attracts, and if the prosecution is able to prove that fact, then he can be prosecuted under Section 411 CRPC. Therefore, the ingredients of both the sections is most relevant in such type of cases to consider. Section 25 Arms Act has nothing to do with the stolen article, whereas 411, the ingredients is only dependent. The ingredients are different. Therefore, the offences under both the enactment 25 Arms Act and 411 of IPC are two distinct and separate offences. Therefore, it is not hit by Article 20, Clause 2 of CRPC by applying the principle of double jeopardy. That is one case. Then, to the same effect, another case is Mohendra Singh versus State of Punjab, 1998. That was a case where the accused was tried initially for the offence under 399 and 402 of IPC and under Section 3 of TADA, as he had a firearm in his possession. Now later, he was prosecuted under Section 5 of TADA Act. Early offence was taken. Already I was prosecuted. Then the Supreme Court again applying this principle, this test, the ingredient test. PC held that there are two distinct and separate offences. The same act constitutes two distinct and separate offences under two different provisions in the same enactment. Therefore, the bar contained in Article 20, Clause 2 cannot be made applicable to the second prosecution. Therefore, it is not hit by Article 20, Clause 2. It's again the law, whenever section 20 clause 2 is invoked, the feasible test to be applied to decide whether the second prosecution is barred under Article 20 clause 2 and it is hit by the principle of double jeopardy or not, whether they constitute, the same act constitute two different and separate offences under two different sections of law in the same enactment, under two different separate enactments, then the bar under 20 clause 2 will not be made applicable. These are the cases. Now, I will come to another facet of this doctrine of double jeopardy. First, initially, 200 and 202 inquiry, and after conducting 202 inquiry, magistrate having found that there is no prima facie case, prima facie evidence to try him for this offence, dismisses the complaint under 203 CRPC. See, the complaint has examined himself and two witnesses also. Now, after examination, after considering that evidence, magistrate finds still there is no prima facie case against the accused to take cognizance against him or to issue summons to him, and he dismissed the case under 203 CRPC. Okay. Now, whether it is, when again he files another complaint after dismissing 203, under 203, on the same facts, with a different set of evidence. Now the same defense was taken, that already the magistrate had dismissed the complaint under 203, now again the same set of facts, another complaint. Now whether it is hit by this authorized acquit or convict under the principle of double jeopardy. Anyone? Mike Avandaya. Where are these people?
Since the complaint is dismissed, not conducted trial, my lord, that is why the second complaint is maintainable. It cannot be hit by Article 20 Clause 3, my lord. Yes, please.
Because he was not tried yet.
He has not been tried. Once tried and ended either acquittal or conviction, then only he can seek protection. On the prime of that stage is, 200 section.
Article 20 clause, no person shall be tried unless no person shall be prosecuted and punished for the same offence more than once.
Please, my lord. He has not prosecuted.
According to you, since cognizance was not taken against him,
yes,
therefore he was not yet prosecuted.
Not prosecuted and dismissed since the Honorable Court.
Okay. According to you, second complaint is maintainable, not hit by 20 clause 2.
Not hit by Article 20 clause 2.
Anyone contrary to the contrary view?
In any matter, may you please, Your Honor? May you please, Your Honor?
Yes.
Evidence.
First give the answer. So, according to you, hit by 20 clause 2.
He cannot suppress the...
First give the answer, say. Whether he can be tried for the second complaint.
He cannot be tried.
The second complaint is not maintainable. Hit by 20 clause 2, according to you. Now give the...
Trial court or either sessions court.
No, reason given by him, he is not yet been prosecuted. Cognizance was not taken against him. Therefore, he was not prosecuted. Therefore, no bar under 20 clause 2.
Because of the court not cognized the offence against the accused.
Okay.
He cannot...
Let us not waste time. Your friend is correct. Second complaint is not barred. It is not beat by Article 20 clause 2 under the principle of authorized acquit. This is made clear from explanation to section 300. Before reading that, I will come to one point. Now, suppose for the time of framing charges, having found that there is no material to frame a charge against him and the charge is groundless, discharged him. Now the police again file another charge sheet case against him, or a de facto complaint has filed a case against him on the same set of facts. Now he has taken the defense. No, I was It was hit by Article 20, Clause 2. What do you say? Whether it is hit by 20, Clause 2 or not? Huh? Cannot be. Now,
Cannot be, my lord. Since he was not prosecuted.
Okay.
Charge it comes under article exceptions.
For this acquit and authorized convict, and explain is not acquittal for the purpose of this section. Therefore, a mere dismissal of the complaint, the Constitution of India, on the principle of, will take another facet of this matter. We just take simple case on 138. Now PW1 was cross-examined and cross-examined. Matter is coming on for further evidence. At that time, magistrate invoking 256 CRPC dismissed the complaint. Now the second complaint was filed. Or we can take this example. Magistrate, as a case is coming on for evidence of the complaint, because of his absence, invoking section 256 clause 1, magistrate has dismissed the complaint or acquitted him. Second complaint was maintainable or not. ఇక్కడ కూడా ప్రాసిక్యూట్ కాలా మిస్టర్
First complaint has been dismissed.
No?
The first complaint has been dismissed.
Emma?
The first complaint has been dismissed.
Yes. But again, second maintainable అని అడుగుతున్నా.
Not maintainable.
Not maintainable. Why?
In NI Act.
NI Act అయితే?
The party, the burden of proof.
ఇప్పుడు NI Act కాదు, 500 IPC. 500 IPC తీసుకుందాం. Summons కేసు. Magistrate has taken cognizance. Accused made his appearance. Case is coming on for trial. Complaint absent. 256 పోయింది. Second complaint maintainable కాదా?
The complainant has not shown his burden of proof, sir.
Not a good reason. Yes, you?
He cannot seek protection under Article 20, Clause 2, Malad.
Why?
Because it dismissed, the complaint has been dismissed under Section 256,
Clause 1.
Dismissed for default. That's why he can, again he can raise another complaint.
Okay, I want to clarify one aspect because our judicial officers are also present here and some young officers here. Dismissal of the complaint under 256 clause 1 is erroneous. 256, if you say to go to 256, the language employed is acquittal, not dismissal. And erroneous orders are being passed by the courts, and we are also seeing in many cases in the High Court. Owing to the absence of the complainant, officers are dismissing the complaints because of the absence of. That's erroneous order, and it is not contemplated for 256. 256 contemplates only acquittal. If the complainant is absent, magistrate has to pass an order of acquittal, not for dismissal. In fact, dismissal of complaint, once the cognizance is taken, is not contemplated at all. Only at pre-cognizance only under 203 and 204 clause 3 CRPs only dismissal is contemplated. Once cognizance is taken, no question of dismissal, either acquittal or conviction, or at best at the time of charges, discharge or charge him, that's all. So leave that aspect. Now, since the magistrate has invoked 256 clause 1 and 256 clause 1 says acquittal, if the magistrate has acquitted him, then he has to acquit him. Once there was an acquittal, then Article 20 clause 2 applies. Because whether there is a trial or not is immaterial. There must be, if there is an order of acquittal. See, even under 300 CRPC, it says that dismissal or discharge is not an acquittal for the purpose of 300 CRPC. But if magistrates invoke 256 clause 1 and it acquits the accused, right now I can't lay my hand on it, I'll give it, it will be supplied to you all. So in such cases, Article 20 clause 2 applies and the double jeopardy principle applies, and the second complaint or prosecution is barred under both under 300 CRPC and Article 20 clause 2 of the Constitution. Now, although there is some more interesting case on that, because of paucity of time, I am skipping it. I am going to the third principle, that is Article 20, Clause 3, which deals with the testimonial compulsion or rule against self-incrimination. So far as this judgment is concerned, also there is much to discuss, but I will just deal with three aspects on this and I will conclude on it. Section 91 CRPC 160 and 161. Interesting thing is that in all these cases, section 90, 160, 161, the same word or phrase, person, is used. 91, you can summon, court can summon, or the IO can summon a document from a person for the purpose of investigation. 91. 160, investigation officer can examine a person or summon a person for the purpose of investigation. Now 161, investigation officer can examine a person during the course of investigation and record his statements. Now, whether the police officer or a court can summon a document from the accused, which is essential or to elucidate the dispute related to the criminal case. Under 91 CRPC, can a police officer or a court summon a document from the person of the accused? Because 91 says person, a person. It did not say accused or something. Now the prosecution argument is that person means accused, it can be summoned. Now accused takes a defense that summoning a document from me when I am an accused in that case, it amounts to a testimonial compulsion or a rule against self-incrimination, and it cannot be summoned from me. What do you say on this? Anybody?
You cannot seek protection on Article 20, Class 3, my lord, because that document is very much essential for determining the prima facie case against him, Your Honor. Testimonial compulsion does not extend it to such an extent that the important piece of material is in question with him. He has to give. He cannot seek protection. It cannot become under testimonial compulsion.
He has to produce.
Yes, he has to produce the document.
Okay, very good. I will cover other aspects also.
Please, my lord.
Now, during the course of investigation, police takes fingerprints for comparison while he was in the police custody. Now, whether it is by testimonial compulsion or the rule against self-incrimination, accused was arrested. Now they want to prove one document which contains his signature. To compare his signature or thumb impression, police obtains his thumb impressions or signatures while he was in custody and sent the same for fingerprint for examination. Now whether obtaining these fingerprints or the signatures from the accused amount to testimonial compulsion.
Then also, he cannot seek protection under Article 20, Class 3. He has the police can obtain.
Why? What is the reason?
That is an important piece of evidence. At times, it may disprove the case against him.
No, evidence okay.
Oh, please.
But he says, Article 20, Clause 3 says self-incrimination.
It has got certain exceptions, Your Honor.
What are the exceptions?
Fundamental rights are not absolute right here. It is subject to restrictions. Since he is a criminal, He has to, please.
No person accused in an offense shall be compelled to be witness against himself.
Please.
I am an accused. They want my signature, my thumb and my signatures
Please,
to use that evidence against me. Therefore,
Yes,
it is
sir.
hit by 20 clause 3,
Yes,
rule,
yes, sir.
rule against self-incrimination.
Yes,
or
sir.
testimony.
Yes, sir. In the larger interest of the
Okay, come
public,
on.
Your Honor,
I'll cover.
My Lord, you can.
No, okay. So far as this testimonial compulsion is concerned, 11 judges bench of the Supreme Court long back in 1961 answered this. 11 judges bench. In 1961 Supreme Court, 1808. 1808. In the case of this AR 1961 Supreme Court 1808, and Supreme Court held that it is not hit by the principle of testimonial compulsion or the rule against self-incrimination. Ultimately, what is held that, in the wording itself, testimonial compulsion. Testimonial compulsion. If the testimony is obtained by compulsion, then only it is hit by the principle. And if they are voluntarily given, voluntarily taken, then it does not amount to bar under 20, class 3 of IPC. That was decided in this. And this was subsequently again followed by another 5-judge bench in 1965. Now coming directly to the point, whether a document can be summoned from the person of the accused is concerned under 91, you say that it can be summoned and the principle is not applicable. But interestingly, the law is otherwise. They said that it can't be summoned. It can't be summoned. It is hit by this principle of self-incrimination principle. But if we compare the law relating to this 91, 160 and 161, where the same word person is used, we have to say that while interpreting the word person in so far as 91 CRPC is concerned, the apex court held that it excludes the accused. That person, word person used in 91 excludes accused. Therefore, police or court cannot summon a document from the person of the accused where he is an accused person in that case. But while interpreting the same word person, while dealing with section 160 and 161, Supreme Court interpreted that it includes accused. It includes accused. This was what, in fact, I had an occasion to deal with this, all these provisions in the judgment of Kadiyala Simhachalam versus State of AP. It is a case arising out of Rajahmundry only. In this case also, police summoned the document from the accused under 91 CRPC, and that was challenged before the High Court. And here, at para number 7 and para number 24 of the judgment, elaborately this was discussed. See, in a way it calls, para number 7, in a way it calls for interpretation of the term person used in 91 CRPC. Adverting the same at the outset, it is noted that similar term person is used in 161 came up for interpretation before the 3-judge bench of the apex court in Nandini Satpathy, and it is held that the same term person used in 161 CRPC includes accused person. Relying on this said judgment, Madras High Court also held that person includes in 161 CRPC accused. But in Haravenkata Satyanarayana case, it is held that the person used in 161 CRPC also includes a person, but the 91 it says person, it does not include an accused person. Finally, summing up the law, at 24, also, while dealing with Nandini Satpathy case, 3-judge bench of Supreme Court, that was Nandini Satpathy was the ex-chief minister of Orissa. After her term, she was sought to be prosecuted by the CBI. And She was summoned under 160 CRPC to record her statement on 161. Now, she challenged that when I am an accused in the crime, how can I be summoned as a witness under 160? And how can my statement be recorded under 161 CRPC when I am an accused? And it is contended that 160 and 161 says a person can be summoned by the IO, police. 161 also says a person can be examined by the IO. So, accused will not come within the purview of that person was the argument of Nandini Satpathy. But the Supreme Court answered, three-judge bench, this is a judgment of Justice Krishna Iyer, while dealing with the earlier law and all the earlier precedents, ultimately interpreted that the word used in 160 and 161 CRPC person includes accused, and the police officer can summon the accused person also under 160 and also examine him under 161 CRPC. That is the law laid down in Nandini Satpathy and in Satyanarayana's case. But when the same word person that was used in 91 CRPC was interpreted, it was interpreted by the 5 judges bench of the Supreme Court in 1965 that it does not cover accused. He cannot be summoned. And that is the law, that is the judgment 5 judges bench still holds the field now. So, the law which is now prevailing at present is document cannot be summoned from the accused on 91 CRPC. But an accused can be summoned on 160 CRPC by the IO for examination even though he is an accused, and also his statement also can be recorded on 161 CRPC. That is the law laid down in Nandini Satpathy. All these 3 judgments are discussed in this Kadiyala Samachalam recent judgment of our High Court. If you go through this, you will have a comprehensive idea of all these law relating to this 91, 61 and 62, relating to this testimonial compulsion. And in the 11 judges bench, they have very nicely interpreted that since the requirement of law is testimonial compulsion, when the testimony of the accused person is not obtained by compulsion, it is not hit by Article 20, Clause 3. So what is required? The test is whether the testimony of the accused is hit by this 20 Clause 3 is that whether it was voluntary or by way of compulsion. So that is what it is held. Simply saying I am an accused and my evidence is sought to be collected is not sufficient. Something more is required to show that it is hit by 20 Clause 3. What is something more? Something more is that it was obtained by way of or sought to be obtained by way of compulsion, by way of threat, inducement or something, harassment, something. So compulsion is the prime requirement to contend that it is hit by Article 20, Clause 3. Therefore, although there is also some other case law on this, now we have no time to discuss on this. So, in brief, I would submit that these 3 cases, this Nandini Satpathy and other 3 judgments, 11 judges, 5 judges, bench, clearly clarifies the law on this Article 20, Clause 3. So, this is the only brief overview, that is a summary relating to these 3 basic doctrines of Article 20, Clause 1 of Constitution, which is part of the fundamental rights under Chapter 3 of the Constitution of India. Thank you.
Thank you, sir. Thank you, sir. Within 5 minutes, we will conclude the entire sessions. Now, the felicitation of the learned judges. I request the President and other members and to felicitate the honorable judges.
జస్టిస్ యాక్టింగ్ సీజే జస్టిస్ శ్రీ ఏబి శేషసాయి గారు, తీసుకున్నా రాండి బాబు, తీసుకురా బాబు, బాబు త్వరగా ఇదిగో ఏమంటా ఉన్నాడు ఆంధ్ర మన బార్ అసోసియేషన్ కమిటీ
వన్ బై అన్నాం వన్ బై
ఆనరబుల్ శ్రీ జస్టిస్ చీకటి మానవేంద్రనాథ్ రాయ్ గారుకి సన్మానించవలసిన కూర్చున్నాను. ఒకరు నువ్వు ఇల్లు ఉండు అయ్యా, వాళ్ళు వేసిన తర్వాత కమిటీ కాదు, వాళ్ళు వేసిన తర్వాత
ప్రసాద్ వాళ్ళు చేసుకునేది,
వాళ్ళు కూడా మన కూడా లేవా, ఇద్దరికి తెచ్చాము, ఇద్దరికి తెచ్చాము, ఇద్దరికి తెచ్చాము. ఉండదా, టైం అయిపోతుందంట. బార్ అసోసియేషన్ కమిటీ వారిని సన్మానించవలసిందిగా కూర్చో. ఉండు వాళ్ళు అయిన తర్వాత అన్న ఒక్కరొక్కరు చేస్తున్నా, ఒక్కరొక్కరు చేస్తున్నా. డిస్ట్రిక్ట్ అండ్ సెషన్ జడ్జ్ నెల్లూరు సి యామిని గారు, సార్ మెంబర్స్ ఇంకా ఉండండి, వెళ్ళిపో ప్రతాప్ నువ్వు వద్దండి మేడం చేయలేదు. బీసీఐ మెంబర్ ఆలూరు రామిరెడ్డి గారు, అయిపోయింది. మీ తర్వాత వెళ్ళమన్నారు ఉన్నారు సార్, అంతలో ఉన్నారు. మీరేంటి చాలా ఎత్తుకోబడి ఎవరు చాలా ఆయన దగ్గర ఉందా? ఒక్కొక్కరు పోతా ఉండండి స్వామి. బార్ కౌన్సిల్ మెంబర్ శ్రీ బివి కృష్ణారెడ్డి గారు, వేశారు వేసారన్నా, వేసారు, ఇచ్చారు. రండి సార్, రండి సార్ వస్తున్నారు. ఇదిగో, ఇవ్వండి. బార్ కౌన్సిల్ మెంబర్ శ్రీ కె చిదంబరం గారు, నెక్స్ట్ పోయింది మన రండి, నెక్స్ట్ ఒకరు వస్తుంది స్వామి, పోయేకుంది. మీరు అన్నీ ఉన్నాయి కదా, ఒకరొకరు తీసుకోండి, ఏ కొరవి ఇవ్వండి. బార్ కౌన్సిల్ మెంబర్ శ్రీ వి బ్రహ్మానందరెడ్డి గారు, ఎస్ బ్రహ్మానందరెడ్డి గారు, సారీ. లాస్ట్ అంట, లాస్ట్ అంట. బార్ కౌన్సిల్ మెంబర్ శ్రీ ఎన్ ద్వారకనాథ్ రెడ్డి గారు, అయ్యా మీరు మనోళ్ళు ఒకటి టక్ తీసుకోండి, మనోళ్ళు తీసి పెట్టుకుంటారు. నెక్స్ట్ ఒకటి తీసుకుంటే అన్నీ ఉన్నాయి కదా. బార్ కౌన్సిల్ మెంబర్ శ్రీ వజ్జా శ్రీనివాసరావు గారు, బార్ కౌన్సిల్ మెంబర్ శ్రీమతి రొళ్ళ మాధవి గారు, బార్ కౌన్సిల్ మెంబర్ సారిక, బార్ కౌన్సిల్ మెంబర్ శ్రీ ఎస్ కృష్ణమోహన్ గారు, బార్ కౌన్సిల్ మెంబర్ శ్రీ ముప్పాళ్ళ సుబ్బారావు గారు, బార్ కౌన్సిల్ మెంబర్ శ్రీ ఎన్ రవికృష్ణ గారు, ఉన్నాయి వస్తున్నాయి సెలవులయ్యా, మీరు అందించండి, తీసుకుని తీసుకోండి, ఎవరు తీసుకొని. ఎన్ రవికృష్ణ గారు, బార్ కౌన్సిల్ మెంబర్ శ్రీ శుంకర రాజేంద్ర ప్రసాద్ గారు, బార్ కౌన్సిల్ మెంబర్ శ్రీ పి రవి గువేరా గారు, అన్ని మనం తీసుకుంటాం, ఒకరు తీసుకుంటాం, నేనేసేది లేదు కదా. బార్ కౌన్సిల్ మెంబర్ శ్రీ పి నరసింగరావు గారు, బార్ కౌన్సిల్ మెంబర్ శ్రీ ఎస్ మల్లేశ్వరరావు గారు, బార్ కౌన్సిల్ మెంబర్ శ్రీ వేనాడి చంద్రశేఖర్ రెడ్డి గారు, చెప్తాను ఆయన వేసిన తర్వాత చంద్రశేఖర్ మనం తీసుకోండి, మనం ముఖ్యం తీసుకోండి, మన శాలువా తీసుకోండి. బార్ కౌన్సిల్ మెంబర్ శ్రీ వేనాడి చంద్రశేఖర్ రెడ్డి గారు, బార్ కౌన్సిల్ చైర్మన్ గారు శ్రీ గంటా రామారావు గారు,
అదే చేస్తున్నా నమస్తే అన్న వాళ్ళు ప్రెసిడెంట్ గారు ఇవ్వమంటే ఒక నిమిషం ఉండండి సార్, ప్లీజ్ ప్లీజ్. ఒక సాల్వ్ ఏమండి అన్నా
కావలి బార్ అసోసియేషన్ సభ్యులు న్యాయమూర్తులు వారిని సన్మానిస్తున్నారు. కోట బార్ అసోసియేషన్ సభ్యులు న్యాయమూర్తులు వారిని గూడూరు సూలూరుపేట సభ్యులు న్యాయమూర్తులు వారిని సన్మానిస్తున్నారు. థ్యాంక్ యూ సార్. చెప్పా సార్, మీరు చెప్తారా ఓట్ ఆఫ్ థ్యాంక్స్ అని పేరు ట్రెజరర్ పేరు ధనపాల రమేష్ ట్రెజరర్.
తీసుకురా మళ్ళీ వేసిన తర్వాత చేస్తాను.
పడిపోతారు వాళ్ళు.
అందుకని మేము అందుకే ఆగాం సార్. బయట నుంచి వచ్చేసారు. మన లోకల్గా మేమిద్దరం
వెళ్ళిపోండి, వాళ్ళతో కలిసి వెళ్ళిపోండి.
వాళ్ళ మేనేజర్ వచ్చేసరికి టైం పెట్టేసి అలాంటి మళ్ళీ మనం అడిగి పోవాలి. మీరు వచ్చేసరికి
ముందుకెళ్ళండి.
రోజు నెక్స్ట్ పట్టుకున్నా
అయిపోయిన వారు స్టేజీ దయచేసి దిగవలసిందిగా కోరుచున్నాం.
డిఫెన్స్ రెగ్యులేట్
అయిపోయింది సార్ లాస్ట్ స్టేజ్ ఇది.
Now on behalf of the Bar Council, we will be felicitating the President of the Nellore Bar Association who has cooperated with us for conducting this program. With this, today's program comes to an end, and on this occasion, we will be thanking the ex-members also, Reddy and Hanumantrao Garu, who have been with us all this time. And I request Mr. Ramesh, Treasurer, to propose vote of thanks.
రాష్ట్ర బార్ కౌన్సిల్ మరియు జిల్లా నెల్లూరు బార్ అసోసియేషన్ కలిసి నిర్వహించిన ఈ సెమినార్కి విచ్చేసిన రాష్ట్ర ఏపీ హైకోర్టు ప్రధాన న్యాయమూర్తి శ్రీ జస్టిస్ ఆకుల వెంకట శేషాయి గారికి, అదేవిధంగా జస్టిస్ చీకటి మానవేంద్రనారావు గారికి, అదేవిధంగా గంటా రామారావు గారు, ఏపీ బార్ కౌన్సిల్ చైర్మన్ రామారావు గారికి, అదేవిధంగా మెంబర్ బార్ కౌన్సిల్ ఆఫ్ ఇండియా రామిరెడ్డి గారికి, అదేవిధంగా జిల్లా ప్రెసిడెంట్ బార్ అసోసియేషన్ ఉమామేశ్వర గారికి, వేనాడు చంద్రశేఖర్ రెడ్డి గారికి, ప్రింట్ మీడియా అండ్ ఎలక్ట్రానిక్ మీడియా అందరికీ పేరు పేరున కృతజ్ఞతలు తెలియజేస్తున్నాం.
జనగణ మన जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलसित रंगा तव शुभ नामे जाये तव शुभ आशीष माये गाहे तव जय गादा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे जय हिंद।